Hi, my dear friends, how are you doing? So, guys, two things were unexpected yesterday. One was the range of Glenn Maxwell's, entire batting skill and the length of the sixes that he hit, and it was completely unbelievable stuff. And the second thing that was unbelievable was our paper 4 law paper, the length of the law paper, so to speak. So I was just seeing something. There was a joke when I say I get 23 plus 20, 43 pages question paper, and you have to write 18 questions and 20 MCQs in 3 hours. So personally, I saw the paper just now. I just opened the paper now. I just made some notes, and I just want to do a quick review. So this video is about a quick review of the law paper. Since it was the last time ever that law could be asked, they went all out. Like, bro, let's give everything. So it was an interesting paper, so to speak. Actually, it is not so difficult, but it was definitely lengthy. I understand. So the question will come whether it's fair, unfair, etc. And definitely, I could not try. I would not have been able to write it in 3 hours. It's quite, elaborate. On that note, let us just quickly see. I just downloaded from CA Study, something like that. I just found it online. Cool. So let's quickly go through the paper. It was an interesting paper, a different paper that tried to confuse us in many things. But at the end of the day, it was lengthy for sure. So a quick review of the paper and quick analysis of the paper 4, last ever paper of paper 4 law. So guys, first question was about, you see the keywords is what we need to understand. So it's about the latest audited balance sheet of AB Limited, but the interesting thing again, unlisted non-government public company. So they have given some figures here. Paid up share capital and premium reserve put together, it's coming up to 10 CR, and free reserves is 44.9 crore, turnover 50.5 crore, and all these things. See, if they had asked you any question about independent directors for unlisted companies, then definitely this chart, these figures would have definitely helped, because anything paid up capital greater than or equal to 10 crore and borrowings more than 50 crore and reserves, turnover 100 crore, all those things will come. But here in this predominant thing, we need to see whether all that thing will come, because the question here they're asking about appointment of one extra director. The company is already having 5 directors and they want to appoint one non-independent director on the board. So they have not given anything about independent directors. So here they are telling 2 people have said they would apply. One is Mr. X, who is an eligible director, who has given 1 lakh rupees deposit, and the other guy would be Mr. M, member of the company, has proposed and written a signifying the candidature of Mr. Y. So Mr. X himself, he has gone, and Mr. Y, member, has approached him, but he has not given any deposit. So both were not retiring directors, both came into the thing. So ideally, guys, you should send a notice as per section 160. You should send the entire thing 14 days before the meeting. Here the meeting is which day? 15th November. So you should exclude the day of the meeting and day of sending the notice. In between, the gap must be 14 days. So this one document application went on 30th October. Definitely 15 days is there, no problem. 14 days is there. Similarly, 31st October also, you can say 14 days is there, because I have to count from 1st November. 1st November to 14 November is 14 days. So 15 November is the meeting, so it's fine. So that part is taken care of. All that we have to write in the exam. All the members about the notice, so that all members should receive the notice at least 7 days before the meeting. Right, they received on 6th November. So 7, 8, 9, 10, 11, 12, 13, 14, fair enough. That's fine. 49% of the votes were cast in favor of Mr. X. Did he get majority voting? No. Since 49% votes are done, but he could not get through, that 1 lakh rupees deposit has to be refunded to him, because for 1 lakh rupee deposit, more than 25%, you have to refund. That you have to take. 51% was cast in favor of Mr. Y. But guys, remember, Y, they had not given any deposit. Company objected the selection of Mr. Y on the ground that deposit amount was not sufficient to validate his candidature. Mr. M said, I have only given the proposal. Why should he give the deposit? Advise that our company secretary is correct. So what do you think, guys? So let me open my slog over book. This was the entire question. Let's see the act. It's fine. Let me open the Bare Act. So it was an interesting paper, but yeah, guys, very lengthy, man. Don't know why they're like, last time, bro. After this, I cannot ask this question. Let's just ask the right way. Everything we'll ask. Just like the last man standing, Maxwell yesterday. Let this be the last subject standing. Last time. Let's give it off. You see, deposit amount shall not apply in case appointment is of an independent director. Is this an independent director? No. They have given the question non-independent director. Or a director recommended by the nomination remuneration committee. Is it recommended by the nomination remuneration committee? No. Is it recommended by the board of directors? No. So guys, whatever it is, you should do along with deposit of 1 lakh rupees. 1 lakh rupee deposit is mandatory. Otherwise, it will be a problem. If the procedure is not followed, then the appointment will not be valid. So that has to be done. So regarding this, in this case, Mr. X appointment anyway is not possible, but you have to refund the deposit. And Mr. Y, even though you have taken the approval and even other things are fine, you have not taken the deposit, and hence that would not be valid. What will your answer be? If 65% of paid up share capital is held by the central government, the procedure under section 160 would not apply to a private company. Is this a private company? No. We saw it is a non-government public company. Okay. Will it apply to a government company? 65% of paid up share capital means is a government company. Will section 160 apply to a government company? Yes. It will equally apply. It will only not apply to 100% government company. So if this were to be 100%, no, then this section will not apply. Then it's okay. Even if you have not taken the deposit, it's okay. This was question. I'll just solve few questions. I'll not do the entire paper. I'm just showing you a review of how it is. This is first one. Next one we'll see. Mr. A is one of the directors of XYZ Private Limited. So always, guys, please go through these dialogues, okay? If XYZ Private Limited. So then he has been convicted by a court of an offence involving moral turpitude on 31st March 23 and sentenced to 7 months imprisonment. Guys, whenever moral turpitude comes, it should be minimum 6 months imprisonment. Right? More than 6 months. Filed an appeal against his conviction on 30th June. The court dismissed the appeal. So guys, this is basically an appeal saving clause. Under section 167, there is an appeal saving clause. Within 30 days of the conviction, you have to prefer an appeal. Point number 1. When was the conviction done? 31st March. When was the appeal done? 30th April. Is it within 30 days? Yes, it is within 30 days. No problem. Then once the higher court dismisses the appeal, you have 7 more days to prefer a higher appeal. On 30th June 23, the court dismissed the appeal. No problem. So within 7 days, till 7th July you have time. You can prefer one more appeal. So yes, you can prefer one more appeal. No problem. Referring to the provisions, whether Mr. A can continue as director of XYZ Private Limited. So guys, section 167 speaks about vacation of the office, and if you see in this, the office shall not be vacated in case of these things. So until the appeal is pending, until further appeal is disposed of, the vacation will not take effect. So the answer to this question is, can he continue as a director? Yes. But can he be appointed as a director of D Limited in July 2023? In July 2023, when the appeal is pending, vacation has not taken effect. But is it disqualified or not is the question. I had discussed these type of areas in our classes, and I told you this is the level that people will ask you. Some of us did not believe it, and there you go. Institute is not playing around anymore. Questions are getting trickier by the day. Law, direct taxes, indirect taxes, everything. And now with the advent of the new syllabus with the integrated business solutions, it is gonna get more trickier. So, yeah. So if you remember, we had launched IBS, Integrated Business Solutions, recording with Tarun Raj sir and Chinmay sir. Some hero commented below. I'll just say, my team had forwarded that message. What did they say? They said, the institute has not released the material only, but these legends are already recording. Whoever has commented, for your information, my brother, institute had not released any material for paper 6 also, which was there earlier, multidisciplinary case study. They will not release any material, but they will release case studies. We are just waiting for the case studies to be released, and then recording will begin. Already begun already. So material will not be given. It will not be like that only. Anyway, moving on. So what I am trying to tell is, institute will not spoon feed you anymore. It is going to be tricky questions like this. Moving on now. Guys, that is conviction. But here, if that is vacation, you see disqualification though. Convicted of an offense. The disqualification will not be pardoned at all. Vacation can be stayed, not disqualification. There is no appeal saving clause for disqualification. So, very simple. 167 he can continue, but he is definitely disqualified under 164. In 167, no way they say that the office will, the director shall not be disqualified. It says office will not be vacated. Disqualification will continue. So yes, definitely it is. He cannot be appointed for sure. Next, Surya is currently serving as managing director of Mata Capital Limited. Has been person instrumental in developing the company. Even after attaining 70 years, suddenly it should strike. The moment you attain 70 years, two things you can take. One, special resolution plus explanatory statement, or ordinary resolution equivalent plus CG approval. Both should happen. Either this or that. Either you take special resolution and explanatory statement, or ordinary resolution equivalent plus CG approval. In this particular case, let's see what has happened. Votes in favor were 60%, votes against were 40. Ordinary resolution equivalent has happened. Analyze and state the compliance requirement. So is special resolution passed? No. So what is next thing? I should take CG approval. So applying the provisions. For continuance also, yes, because under 196 it says no managing director shall be appointed or continue the employment of. So yes, we had discussed in class also, 70th birthday along with birthday cake, special resolution has to be passed, or ordinary resolution equivalent plus CG approval needed. Two major shareholders received complaints that some stakeholders, that some directors were involved in some serious fraudulent activities. Inspected the books and then they rushed to seek your approval with respect to SFIO. Advise them the scenarios in which the investigation can be initiated. Very easy theory question. These are the scenarios. 210, 212, 213, 216, 219 scenarios. You have to explain that quickly. Also advise them whether majority can have any powers in this regard. So majority powers would only come, what do you say? In this particular case, you can say in 212, on intimation of a special resolution passed by the company that its affairs are required to be investigated. So you can say pass a special resolution and move ahead. You can apply to SFIO. But technically SFIO only will be looking at high value items. So yeah, you can go with a normal 210. And if the money value is good, they will go to 212 anyway. Again, see intimation of a special resolution. Same thing. So to explain that simple question. Due to some recent sales and purchase, the present shareholding pattern are as under 10,000 shares held by Mr. Wright, 8,000 shares held by Mr. Steve, 1,000. So majority shareholders is Wright, 80% he has. This fellow has 10%. So 90% already done. Then Sarah, then Shubman, Shan. Sarah is there, Shubman will not come. And this fellow Shan is deceased, poor guy. Mr. and Mrs. Smith, 730. So all this will be 1,000. So this is minority shareholding, this is majority shareholding, 90%. Steve enters into an understanding with Mr. Wright to help them acquire the remaining shares. So guys, this is what acquisition of minority shareholding by the majority. And an offer for buying the remaining shares at a price determined by the registered valuer. Sarah rejected the proposed offer. Okay. Sean's legal heirs had not made an application for the transmission. Negotiated for a higher price. Easy guys. What is the answer? What will be the role of Bright Limited in this transaction? What will be the position of Sarah who rejected the offer? What will be the situation of shares held in the name of the deceased shareholder? Very simple. This could be, this one, purchase of minority shareholding by majority under section 236. In the event of an acquirer holding 90% of the issued share capital, that example, Smith and the other fellow has 90%. Then I can ask the other, can take over the other shares. And the price determined by the registered valuer. The majority shareholders shall deposit an amount equal to value of the shares in a separate bank account. So that first question, what is the role of Bright P Private Limited? It is just a transfer agent. It is a company whose shares are being transferred. They are only act as a transfer agency. It's there in our summary book. This is the answer. They will only act as a transfer agent. What is the role of Bright Private Limited? Transfer agent. And one fellow died or deceased, etc. They will make an offer and their shareholding shall continue, rights will continue for 3 years. That is what you should write, 3 years. And if they negotiate a higher understanding, etc., they should share the additional compensation. Where a shareholder or majority equity holder fails to acquire full purchase of the shares, then provisions of the second shall continue to apply to the residual minority equity shareholder. That lady Sarah, residual, she did not agree, so it will keep on applying. That's all you have to write. So they are given good question on section 236. Generally this area people don't ask, but they have asked this time. One question on FEMA. This is your overseas investment rules 2 marker. Then this is one 3 marker in FEMA advance payment that given. Winding up one simple question was there. Liquidation simple area. One question on registered valuer. In this connection, chairman of the audit committee proposed to appoint an experienced registered valuer who meets all the requirements. Arvind, member of the audit committee, has the opinion that only board of directors has the power to appoint a registered valuer and not the audit committee. Discuss, advise them. Who shall appoint the registered valuer? What will happen if he contravenes? What is the valuation, etc. Okay, section 247. If he commits fraud and all, it will be under 448, 449, which again comes down to 447, fraud section. Where evaluation is to be made, you see, it should be appointed by the audit committee only or in its absence by the board of directors. In this question, audit committee is already there. So audit committee only has to do. See how they are asking. Mr. Rajan is possession of some huge cash obtained from offense of money laundering. He bought the property and transferred to Hitesh. Case of Hitesh was pending. During the trial, Hitesh came to know that the property had been attached. He mentioned that he was not aware. Okay, if you are not aware, if you then go to the special court after hearing, special court will give you an option and they will do it as you deem fit. The special court will give you, an opportunity of being heard, and they can actually restore the benefits to you. So if in the entire course, one of the assets was seized and that asset happened to be yours, who is not a party to the money laundering, and you can prove beyond reasonable doubt that you are not involved in money laundering, then that asset may be restored, is what the lawmaker says. It may be restored back. So that is what it is. That is this question. So can you consider the claim and can direct restoration? Yes. About on SEBI board, one question had come. In SEBI regulations, one thing, audit committee can continue after listing of securities, easy. Then one FCRA, one question with respect to when can the letter be renewed? That one question had come. This is also simple. Renewal, etc. can now go through only to electronic form. FC2, FC3, FC4, all those things. Other things will not be valid. Settlement agreement, this is your arbitration conciliation. One question had come. NCLT question. This is your conciliation panel. NCLT order, mediation and conciliation panel. Two experts they will do, forward the recommendation to the tribunal. Recommendations were not given with the prescribed time, same cannot be accepted. So there is nothing related to any appeal to whatever the mediation and conciliation panel does. So that is regarding that. So that you can check our Companies Act 442, mediation and conciliation panel. Arrive between the parties. Central government shall pass an order or judgment making the said mediation agreement as part thereof. They will do the needful. Reference to mediation. So it was substituted by the Mediation Act with effect from a date to be notified. This is why they gave this question, no, mediation panel, because Mediation Act had amended section 442. So that particular question that they had asked was based on the previous law. This is the previous law. That's why they asked the question. The mediation and conciliation panel shall follow such procedure and dispose of the matter within a period of 3 months. Any party aggrieved by the recommendation may file an objection to the central government as the case may be. In this question, what have they told? And they said this, therefore the same cannot be accepted. Referring to applicable provisions, decide whether the condition of company is tenable. It should be sent within 3 months. You see, 10 July. They did it within 18th. August, September, October. They should have done within 10th October, you see. They'll appoint experts, all that is okay, same thing they are given. Within a period of 3 months on the date of such reference, dispose of the matter within 3 months on the date of such reference. So from 18, they should have done it within 10th October, they did not do it. Party aggrieved can file objection to the CG or tribunal, that's all, or appellate tribunal. So they can go to CD or NCLT or NCLAT. Nobody else. Here, where have they gone? Yeah, you cannot say same cannot be accepted. You cannot say that. You can prefer an appeal. Whether and before which authority the recommendation of panel can be challenged. So as I told you guys, section 442 was amended in 2023. That's why this question came. So Samuel D'Souza submitted his candidature for being a resolution applicant of Arch Chamber submitted in pursuance of an invitation made to a prospective resolution applicant under 25(2)(h). Okay, resolution applicant by Mr. Ashok Taylor, resolution professional. Samuel D'Souza is a spouse of a sister of Mr. Vincent, who is going to be involved in the management. Okay, this is a question on 29 capital A. Mr. Vincent is in the management. His sister's spouse is Samuel D'Souza. Is he a related party? Let's see the related party definition. With reference to any person means who is a relative to one another. Wife, sister, brother, sister. Wherever relation is a son, daughter, sister, brother, their spouses also shall be included. Yes, spouse of a sister will definitely be a related party. Relative. And is relative a related party? Yes. See, related party with respect to an individual will be means a person who is a relative of the individual. So yes, anything with respect to the spouse, sister, spouse, everybody will be covered. That is one part of the story. Samuel D'Souza being a resident, he himself is convicted under FEMA. Oh. So first of all, is this fellow related party? Yes. Second, he is convicted under FEMA for an act specified under 12th schedule. Imprisonment of 2.5 years and only 1 year and 3 months as expired from the date of release of his imprisonment. You see in 29 capital A, if you have been convicted for any offence punishable with imprisonment of 2 years or more, you should at least wait for 2 years from the release of imprisonment to be able to be eligible to be appointed as resolution applicant. Since that is not done, is he eligible? No, he is not eligible. That is what you have to write. Good question. Following towards remuneration. Total amount of remuneration paid to 16 employees. Amazing. Guys, this is Narayan Murthy's point. Narayan Murthy always told you should always compare how much the midpoint employee, median employee is earning with the compared to the top guy. Correct? So you should do the ratio of that to the top, median to the director remuneration. Point of disclosure to be made. So it is the median employees remuneration, the disclosure in the board report you should mention. So it was part of section 134. And the way they are asking questions is hats off to them, guys. Really hats off. Is definitely difficult for the people to check all this. In the board report you have to mention. And 197, disclose in the board report. Board report I showed you 134. Ratio of remuneration of each director to median employees remuneration. Each director. 3 fellows are there now. Mr. A is to median. Mr. B is to median. Mr. C is to median. How many times? If the median is 5 lakhs, A is earning 6 times, B is earning, 7 times, like that, 7 point something, like that. But how to arrive at that 5 lakhs? So to compute the median. See, they have given brilliant. People, 2 minute silence for the ones who have just mugged up directed to median. We have discussed in class what is median. I told you, I think it's in a marathon also, you can check out. Arrange everything in the ascending order of salary. And then the midpoint employee, not the average. If you have done in the exam 1 plus like 16 all add and divide by whatever, gone. So arrange it in the ascending order. Least being something, how much is the least? I think 10 lakhs. This is point number 1, this is point number 2, like that you have to search and do it. This is point number 3, like that ascending order you arrange. And midpoint will be the 8th guy, that's it. So basically you don't even have to do everything. First top 8th one you take, that only is the median. And directly divided by median. Very good question. 4 marks. Very good. See, median employees remuneration along with the required ratios, please tell, they have told. Deadly. I had a board meeting via video conferencing, which was the last day of the 120 days interval. Okay. Notice specified the venue of the board meeting at the registered office. The company secretary and 1 director participated in the registered office. Chairman, all other fellows sitting in Shimla. No problem. All recordings were done. First agenda was appointment of director as Mr. Jain as a director of XYZ Limited. Okay. Maybe additional director is what they are saying. One of the directors, Mr. Yash, attended the meeting through audio conference. What is the venue of the board meeting and validity? Venue of the board meeting can be anywhere in India. And for certain items like approving the board report, etc., you needed to have physical quorum before. That was recently removed. That was removed in 2022. So now in board meetings you don't need a physical quorum. No need at all. Audio conferencing fellow will be allowed, definitely, to participate in the meeting and will be counted in quorum also. Easy question. The nomination committee. Reporting entity. See, they are told you opened a current account with ICBD Bank. Huge cash deposit was made and foreign remittance also you wanted to do. You wanted to also buy an expensive car. As compliance officer, explain the enhanced due diligence. 12AA. I had opened the Bear Act that time. Yeah. This came from 1/8/2019. I was telling you that I never asked in the exam. Ask this time. Verify the identities of the clients. Take additional steps as may be prescribed. Record the transactions. If it is likely to involve proceeds of crime, immediately we should bring the take into account also the future monitoring of the accounts. So gist of this 12AA you should write. Theory question, direct. Then on resolution plan related stuff. That's fine. Guys, technically paper was lengthy and it had asked the nitty-gritty into small things that definitely asked. So those who always go behind the some summary, chart, methodology, all will be, it will definitely impact them. Let's forget about this. Let's think about the future. Definitely going ahead, examination is not going to be easy. It is going to be tricky only, especially your first group, second, whatever. The only two groups are the 6, and your SPOM, that is your self-paced also will not be easy, is what the information I have got. So new syllabus fellows, please start studying. Old syllabus guys, don't worry, just finish this off. If you clear, good. Otherwise, anyway, I have another attempt. Okay. So if you have anything, you can message me below. I will try to reply. Okay. All the best. Take care. Do your other exams properly. Okay, guys, love you all. Take care.